Hey, Kim, you can go ahead and start the webinar. Are we live, Kim?
You're on.
Great. Well, thank you everyone for joining us.
My name is Ben Hamilton. I'm the Executive Director of Ontario One Call, and welcome to our presentation on bylaw changes. These bylaw changes will be proposed at the June 16th annual general meetings for the members to vote upon by ballot. And thank you for joining us. We'll give you an overview of the changes and why they're happening, and also give you a bit of context to why they're happening. And at several points during the presentation, we'll stop to allow participants to pose some questions. Adam Morden from Ontario One Call will be monitoring the questions, and I'll ask him a few times during the presentation just to pose some of the most frequent or regularly occurring questions that are coming from today's participants. To ask a question is pretty simple. Just hit the question mark icon on your toolbar, and you can just type your question in there and Adam will ask it for you.
So on the next slide in the presentation, I hope today just
take an hour, so I don't want to take too much time, and talk about why One Call is looking to make changes to its bylaws, the reasons and motivations behind it, and also related to other things that are going on in terms of Bill 93 and dedicated locator. I'm sure some of you will have attended the recent webinars we've held on both those topics. And if you haven't, they are on our website and on YouTube as well. And I'd encourage you to check them out if you want to get more information on some of the more detailed contents of Bill 93 and dedicated locator. So there are a lot of changes that need to take place in our bylaws to reflect the changes of Bill 93. Of course, Bill 93 was introduced in March of this year, passed in April, and it made a number of important changes to improve the way the locate industry works and to open up opportunities such as dedicated locator. It also made a lot of changes to compliance. So in Bill 93, the concept of a compliance committee at Ontario One Call and an Ontario One Call appeals committee was removed. And in its place was developed something that's more like the ESA currently has, which is a scenario where an inspector or a staff member applies a penalty against a One Call member or excavator, and then there's a process for a staff review and an appeal as well. So there's also that important change to the compliance process. And we'll talk about some of the changes and how One Call's bylaws and policies will relate to that, and also work that the Ministry of Government and Consumer Services is currently doing. So that's the first big change. The compliance model was altered. A lot of governance items were changed as well. Also includes the power of the Minister of Government and Consumer Services to make appointments to the Board of Directors. And that's very similar to powers the minister has in relation to delegated administrative authorities like ESA or TSSA. There are also a lot of operational changes as well, such as the use of dedicated locator and 60-day validity periods for the lifespan of a locate. So a lot of operational and governance changes. Changes are to our compliance model. And because of legislation change, we have to change our bylaws to make sure our bylaws are up to date and they reflect the language and the concepts that exist in the law. We're not really allowed to have a set of bylaws which contradict or are not aligned with the laws of the province.
On the next slide, we're changing some
Names of familiar bylaws and schedules. What we currently have is bylaw number 2. There was a bylaw number 1 in a previous model of Ontario One Call. That was replaced by bylaw number 2. And bylaw number 2 is really the governing framework of the organization. It talks about the board of directors. It talks about members' meetings. It talks about how votes are to be held. Under bylaw number 2 are some schedules, including Schedule 2 and Schedule 3. Bylaw 2, Schedule 2 is probably the best known. That is the bylaw section that relates to the rules of membership. That's where most of the language around compliance against members lives.
There's also bylaw number
3, which deals with compliance against excavators. One important change that Bill 93 made was that compliance, which previously was only a condition of membership, and thus really applied to the members, the owners of underground infrastructure, that concept was expanded to now include excavators. So what that means is in the future, Ontario One Call's compliance activity can be directed against members for their violations of the Act, so things like not providing locates within 5 business days, and can also be directed against excavators for violations of their responsibilities under the Act, including things like not calling for locates or digging without locates.
So what happens with the new bylaws is that they have new numbers. So the existing bylaw number 2, dealing with governance, becomes bylaw number 3, and the previous bylaw is retired. The existing bylaw number 2, schedules 2 and 3, become the new bylaw number 3, schedule 1. There was an old bylaw 2, schedule 1, that's been previously repealed. So
schedules 2 and 3 dealing with member and excavator compliance now becomes one schedule dealing with both excavators and members.
On the next slide, and after this slide, I'll
pause for some questions.
These are some of the
changes made to the overall bylaw. So there's a new number, it goes from 2 to 3. And any changes here are really about the governance structure, how the board is done, how the board committees work, things like that. So of course there's changes to committees. All the reference to the compliance committee and the appeals committee are deleted.
Those have been superseded by new concepts that will exist
in other parts of the bylaw, and also the upcoming regulation from the Ministry of Government and Consumer Services.
It adds language where the minister may appoint directors to the board. Again, this is to make sure the bylaws are aligned with Bill 93. It also creates
power for the board to create 2 documents, one called rules, the other called policies.
At the end of the presentation, we're going to discuss these in some detail, but basically
the rules document is a summary of all the obligations of members and excavators under the Act and bylaws. So it will be a single document where if you're a member, you can see everything you're obliged to do in terms of delivering locates, what constitutes a proper locate, and also in terms of the bylaw, your technical requirements in terms of providing information and mapping to Ontario One Call.
For excavators, it'll describe your legal obligations under the Act, such as calling for
locates and not digging without locates,
and also describe any obligations you have under the bylaws. So it'll be a single document which summarizes all your obligations under the laws and bylaws. The policies document is more specific, and the policies document will, which has been shared
with the Ministry of Government and Consumer Services, is really the mechanics of compliance. So the rules document explains things like how
not providing locates within 5 business days is an offense under the Act, but it doesn't describe what happens if that is broken. The policies document
is what describes the consequence of late locates, the mechanism to determine and evaluate offenses under the Act, and also how financial penalties and other disciplinary actions could be applied. So the policies document is really the detailed aspects of how compliance will be applied to members and excavators. These documents are currently in draft format. They've been shared with the Ministry of Government and Consumer Services. The rules document just summarizes legal obligations. That'll be approved by the board of directors in due course. The policies document, the One Call board has provided the ministry with their insight into how they feel it should look. And currently the Ministry of Government and Consumer Services is developing a regulation based on the policies document provided by the board, but also bringing in other aspects of compliance that relate to other DAAs and other considerations the government may have, and are developing the regulation that'll be signed off by the Minister of Government and Consumer Services, likely sometime this fall. And once that occurs, our policy will reflect the regulation passed and signed by the Minister of Government and Consumer Services. So the policies document will be aligned with the ministry's regulation, and all the how-tos about how compliance will work, including things like an appeals process, will be described in those policies. So I'll pause there and ask Adam if there's any questions that the listeners today would like to put.
Thank you, Ben. Just first, before we get into the questions, we are getting some feedback that some of this is coming across a little bit muffled. I don't know if there's a way to make sure that the microphone is a little bit more accessible to yourself.
Sure, let me
make
switch.
It a bit clearer.
Yeah, I'm going to switch to another microphone here. That might help.
Okay. And then let me know when you're ready for the questions.
Yeah, I'm ready. Hopefully this is better.
Yeah, that's much clearer. Fantastic. Okay, so the first question we have is regarding the 60-day validity. Just want some clarity on, is that required of the members today, or is there a time frame when the members should be reflecting that 60-day validity?
So that's currently in place now. Once the legislation was signed off by the Lieutenant Governor back in April. So currently members now must provide locates with a minimum validity period of 60 days. They can do that for beyond 60 days if they choose. I know some members do that, but currently, as of now, locates must be valid for at least 60 days.
Okay. We have a question to ask a clarification of what an AMA is.
So an AMA is an administrative monetary amount. It's basically government talk for a fine or financial penalty.
Okay, thank you. The next question is about the owners of underground infrastructure currently that do not fall under the regulations, such as Metrolinx, CN, and CP. Does this change in the bylaw change how they have to respond?
It doesn't. As you note, provincial agencies are not obliged to participate under provincial law. That's something that's left up to their discretion. We've certainly encouraged groups like Metrolinx and the Ministry of Transportation to participate in Ontario One Call. We'll continue to do so, but they're not covered by these laws or bylaws.
Okay, so a question about the rules and policies. Will they be written to align with existing legislation, such as Regulation 210, which the TSSA enforces?
That's a good question. The rules document will really summarize the obligations under Bill 8, the Ontario Underground Infrastructure Notification System Act, as it's been amended, and the bylaws and regulations. So it's just going to stick to the Bill 8 regime. The policies, and as you know, there's different agencies, both federally and provincially, which have requirements. The ministry will certainly consider in the development of their regulation the proper alignment between the policies and penalties and overall compliance framework. they'll consider that in relation to those other legislative frameworks. And ultimately, our policies will reflect what the government and minister ultimately sign off on.
Okay, thank you. And that's the questions that we have at this time.
Great. So we'll talk about the next slide, which is a new schedule. So the new bylaw number 3 is the overall governing bylaw. Underneath that is the new Schedule 1. So this is the old Schedules 2 and Schedules 3 brought together. The changes here are so substantive that we couldn't even provide a redlined version. It's not only merging two documents together, it's also changing a lot of concepts and terms. So we're going to go through that and review it with you right now. So again, the power for one call to make rules and policies is established. The rules document itself will be approved by the board of directors and reviewed annually by the board of directors. Bill 93 also requires one call to publish certain compliance information. That is now included in the bylaws under this schedule. One minor change that was made as part of Bill 93 is a definition of emergency locate. Previously, the language talked about having to complete the locate within 2 hours. Now the requirement is a member must attend the site within 2 hours. So you must physically be on the site within 2 hours. That's a slight change, but again, thinking of geographic areas where it might be difficult to access an area, and also scenarios where access to provide a locate might be limited by an emergency response, that's still an important change to note. And from one call's perspective, the most important thing is that members have a plan and have staffing and are able to ensure that they're able to have a 2-hour response time, even in non-peak periods. That's the important part. If the locate's provided 2 hours and 15 minutes, that's okay. If there's emergency services who are controlling the site, that's okay too. But our primary interest is to make sure that members are able to get to their infrastructure within 2 hours. There are scenarios where that's not particularly possible, talking about extremely remote areas and inaccessible areas, but generally speaking, that should be the response time to attend an emergency site. So that's a minor change, and there are changes to the bylaws to reflect that. As one of the questioners mentioned, the minimum locate validity period is now 60 days, so that will be updated. We used to have at one call a rather convoluted, lengthy process around compliance. It started with a compliance committee that was essentially a form of peer-based justice. And then you would have an appeals committee, which would be a subset of the board of directors. Those were complicated concepts, both to explain and to undertake. And Bill 93 drastically simplified that process, as I discussed earlier. And in doing so, the need for a compliance committee and appeals committee no longer existed. So just as in the main bylaw, bylaw number 3, all references to the compliance committee and appeals committee are deleted. It creates the requirements for one call to have the rules document, and we've talked about the rules document and the various aspects that go into that. There'll also be a dispute resolution policy. That will also appear likely in the ministry's regulation as well. So it'll be very clear for members and excavators to understand, first, what their specific legal duties are, and second, if there's a penalty or action taken that they don't agree with, how they can appeal that and receive further consideration. It also adds different criteria such as severity, history, and remediation to help guide compliance decisions. This will likely be further refined in rules or policies or the MGCS regulation, but generally speaking, this language is included to help Ontario one call sort between different offenses and have more of a risk-based approach in terms of how it approaches compliance. So those are the aspects around schedule number 1. Again, this merges the old rules for members and the old compliance on excavators bylaw. So Adam, any questions on that section?
We do have a couple. The first one's regarding emergencies and the requirement to be on site. And just a clarification, does someone need to be on site to receive the completed emergency locate time-wise?
The law doesn't really talk about that. There are certainly scenarios where different crews might be responding to the emergency, or there might be people on site who may not be the people completing the actual make safe work. But there's nothing that exempts an emergency locate being provided if the person is not there. They definitely should be there, quite obviously, but it's not like if no one's there, you can just drive off and ignore the fact there's an emergency.
Okay, great. So the next question is asking for clarification why bylaw number 3, Schedule 1 includes requirements that are included in the Act.
That's just for, and of course this was put together by our legal counsel, that's just to provide a more complete set of bylaws. One thing we want to do, and this is also why we're doing the rules document as well, is to make sure that people can get a full understanding of their legal responsibilities by looking at the bylaw and the rules document, and they don't have to basically read their first 10 obligations in the legislation and then read another set of bylaws to understand obligations 11 through 20. So that's one reason a lot of concepts that exist in the law are repeated in the bylaws too. They're also different as well. The law is the provincial statute. There's a lot of things that aren't really dealt with in the law. That's the legal framework. The bylaws are really meant to be more of a the rules of membership, the rules for excavators, and a more detailed document. So it's not really inappropriate or unusual for concepts that exist in the law to be included in the bylaws as well.
Okay, thank you. There's another question about excavators being included in the bylaws. And is it just solely for making the request for a locate, or are there other areas that cover the excavators in the new bylaw?
Yeah, so if you look at the Ontario Underground Infrastructure Notification System Act, Bill 8, which has now been amended through the Broadband Act last year and Bill 93 this year, it's not a very long piece of legislation, but it does include very specific obligations on excavators. So things like having to call for locates, things like not digging if you don't have locates. There's also an obligation that an excavator ought not to dig in a way which they know could create a damage. So the list of obligations on excavators is much shorter than the list of obligation on members, but there are still those obligations there. And with the changes to Bill 93, they now fall under the same compliance regime as member offenses do. Previously, they were still violations of the law. And in theory, one call would have to take an excavator to civil court because they weren't subject to the terms and conditions of membership as excavators. So I would say it's much more preferable to have a straightforward compliance process as opposed to the concept of one call taking excavators to court. And from the members' point of view as well, it makes sense that members and excavators are treated equally and put on a level playing field when it comes time to judge them for their compliance with the law. So I think it's important that they be put on equal footing.
Okay, thank you. And that's all the questions we have for this moment.
Great, thanks Adam, and thanks for the good questionnaires as well. So items maintained in the new schedule. Those of you who are familiar with the old Schedule 2 will remember that there's a lot of technical language, and that language is carried over into the new Schedule 1. So some of the very familiar concepts, mandatory use of 360 feedback is continued. All those technical aspects around processes between members and one call is maintained. Importantly, all the issues around who owns data, how insurance is handled, confidentiality, all of those are carried over from the previous schedule. For the most part, those of you who just deal with the day-to-day operations of Ontario One Call, in effect, the bylaws don't really change anything around that. There's some changes to legal concepts such as emergency locates and 60-day locates. There are changes to the compliance structure, but for the most part, the business of submitting locate requests, of maintaining your equipment and records, of communicating with Ontario One Call, all of those are maintained as they currently are in the bylaws. And our last major slide is just to talk about some of the building blocks of the compliance regime. And some of you on this call, will have a lot of interest about compliance and where compliance is going and how all this fits together. This document and this slide is really meant to help you understand how all these parts relate to one another. So first off, there's the legislation, Bill 8 as amended over the last couple of years and most recently through Bill 93. So the original Ontario Underground Infrastructure Notification System Act, OINSA as the acronym goes, is still there. It's been amended, but that document still exists. That legislation is the overall framework. It lists all the legal obligations of the members and the legal obligations on the excavators. And it also empowers Ontario One Call to provide compliance over any act of non-compliance from either members or excavators. Supporting that, building on the legislation, are the bylaws. And the bylaws establish the board's powers to make the rules and policies which are binding on members and excavators. And then those two sets of documents that build on the bylaws. The rules is a summary document. It brings together all the obligations on members and excavators that exist in the law and the bylaws, and also outlines how the dispute resolution and appeals policy works. And then complementing the rules document is the policies document. The policies document describes the mechanics about how cases will be dealt with and how penalties and other consequences may be applied on non-compliance. That will be essentially formalized through the Ministry of Government and Consumer Services, the Ministry of Government and Consumer Services regulation, and One Call's bylaw will ultimately reflect what is developed and signed off by MGCS. So in the near future, this will be in MGCS's hands, but you will likely see information and communications from MGCS around their work on the regulation, and perhaps the opportunity to provide feedback and comment on their draft work. So One Call and the ministry are collaborating on that, and I would expect that in the near future you'll hear more from the ministry about their work on that important regulation. So that's really the building blocks of how the compliance regime will work. There's a lot more to it and a lot more detail. It'll certainly be subject to future consultations and likely future webinars in the months ahead, but that's how all these parts relate to each other at the moment. And just on the last slide. So next steps. The bylaws are approved by the membership. So for all the members on this phone call, there's an opportunity to vote at the June 16th annual general meeting, which of course is next Thursday. Members will be provided a ballot. It'll ask for straightforward things such as approving the auditor, approving the slate of the board of directors, and it will also ask the membership to approve the revised and renumbered bylaw and the revised and renumbered Schedule 1. We'll continue to develop our rules document. and also the policies document as well. That will be done in conjunction with MGCS's work on their regulation. To everyone on this call, I would certainly keep your eyes open in the coming months. There will be more information coming from One Call and MGCS on that regulation, and there'll certainly be the opportunity to, again, comment and discuss it as well. And of course, thank you everyone for participating today. I'll ask Adam if there's any final questions that people might have.
We do have just a couple, but just one on the previous slide, a question was asking, where do the regulations fit into the schematic?
That's a good question. I was thinking about where we draw the regulation. I was thinking about drawing it almost as a sun that shines on this pyramid, but then I thought I was becoming a little overwrought with the visual symbolism. Really, the policies reflect the regulation, and the regulation reflects the policies. So One Call and its board of directors have evaluated and considered a variety of proposals for policies and developed draft policies. Those have been shared with the Ministry of Government and Consumer Services, and currently MGCS and their legal counsel are developing what the formal regulation will look like. The formal regulation will likely look similar to the policies developed by the board, but I do know that the ministry is looking very carefully at what other DAAs do and how they can create a framework that is most suitable from the perspective, from their perspective, what they feel best reflect Bill 93. So there's likely going to be some changes made to the policies that the board has passed, but in due course, the ministry will communicate their view of what the regulation should look like, and there'll be a period of consultation and discussion, and ultimately the policies that One Call has will reflect what's in the bylaw. So really the policies and the regulation are essentially on the same footing. They're both the top of the pyramid in the sense that they're the most specific part of this process, and they really get into the details of how penalties will be applied and what is the quantum of those penalties.
Okay, great. So we have a question on where they can review these the bylaws that are being proposed for the vote prior to the AGM.
I believe they were included in the package that went out with this email, so you should have it already. If you don't, please email Kim Smith at ksmith@on1call.com, and she can certainly forward you the documents as well. I'm sure they appear in other places, but it just might be easier to email Kim directly.
Okay, great. And just one final question, asking if this webinar will be made available for viewing at a later time.
It certainly will. Like our other webinars, it will be posted on our website, and I believe on YouTube as well.
And that is all the questions we have for today.
Great. Well, we moved through that pretty quickly, but also we had some very good questions as well. Don't forget that One Call is here to help you work through any changes that come out of Bill 93, whether it's implementing things such as 60-day validity periods, whether you're interested in a dedicated locator, or whether you just want more familiarity with some of the changes made over the last year. Reach out to your contacts at One Call. We're very happy to walk you through the process and increase your understanding of what's been changing in terms of the law and this bylaw. And as I mentioned before, we encourage you to participate at our AGM on June 16th. And also over the next few months, you will see more communication and information about a compliance regulation. So please do keep your eyes open for that. And when you have the opportunity to comment and participate, please do so. This will be a very important regulation from the ministry. The policies and rules documents are going to be very important as well. So we want to make sure we get as much feedback as possible. That's about it from me. So everyone, thank you for taking your time out on a lunchtime on a beautiful Friday. And hopefully we will all be in touch soon. And we look forward to seeing many of you at our AGM next Thursday. And thank you to Adam and Kim as well for setting up this webinar. Everyone, I hope you have a wonderful and safe weekend.